devil, you're evil, you're a monster, you're a...
On December 11th, Cardinal George Pell became the most senior Catholic Church official in the world to be convicted of child sexual abuse. The Vatican treasurer was found guilty of abusing two 13-year-old choir boys in 1996. But the story wasn't covered by local news networks that day. And this is what Australia's newspaper front pages looked like the day after. No mention of Pell and key details left out. The story made headlines in other parts of the world, but it was almost 3 months before Pell's conviction was on the public record in Australia, and that had many foreign journalists wondering why. Before Pell's trial began, the Director of Public Prosecutions asked the judge to grant a suppression order to prevent a real and substantial risk of prejudice to the proper administration of justice. In Australia, suppression orders are used to prevent juries from having information that may unfairly influence their verdicts. That information could include inadmissible evidence or details of previous convictions. In Pell's case, there were concerns that evidence made public during his first trial would prejudice the outcome of a second trial involving similar allegations. On February 26th, that second trial was dropped and the suppression order was lifted. Now, 36 Australian journalists and news organisations accused of breaching that order are facing serious consequences. Some are accused of flouting the order in Australia. Others are accused of helping foreign media organisations report on the matter. The maximum penalty is 5 years in prison and a fine close to $70,000. Legal experts say suppression orders are needed to strike a fair balance between the public's right to know and the defendant's right to a fair trial. But critics say they're outdated and in need of an overhaul.
It's virtually impossible to quarantine juries from social media and the internet. So we need to have legislation that bears in mind this fundamental truth. It has to be necessary to prevent prejudice to the proper administration of justice. And in many cases, that can be done by giving a direction to a jury that they are to put out of their mind the fact that somebody had previously offended.
In Australia, there are more than 200 laws across the country that deal with suppression orders. The Law Council wants those reviewed, modernised and standardised. But there are fears those changes could result in more closed court hearings, which could erode the principle of open justice. Denise Savoya, for Newsmakers.